framework, and that was because
Dear Mrs. Gese, dear Mr. Steng, dear Professor Kohl, dear Dr. Schmid, dear members of the media policy community and friends of North Rhine-Westphalia. A warm welcome to a new edition of North Rhine-Westphalia.Online. Today's topic is the Digital Service and Digital Markets Act. In cooperation with the Media Authority of North Rhine-Westphalia, we want to discuss the impact on the media sector. Half a year ago, the European Commission published its ambitious digital regulation proposals, the Digital Service Act and the Digital Markets Act. Both proposals represent a significant overhaul of the digital space in the European Union and lie at the core of the digital transformation ambitions of the European Union. The new legal framework will have effects on a wide range of sectors. The media sector plays a special role and has specific needs in the online environment. This aspect needs to be taken into account in a horizontal legal framework applicable to all intermediaries. Both co-legislators, Council and European Parliament, have similar ambitions as it comes to the finalization of the projects. The current Portuguese presidency is working on a compromise and paving the way for the incoming Slovenian presidency. On the Parliament's level, the leading IMCO committee, as the other committees involved, are currently working on their draft reports. And the ambitious idea is to close the file under the French presidency in the first half of 2022. Ladies and gentlemen, Professor Kohl has conducted a study on updating the rules for online content dissemination legislative options of the European Union and the DSA proposal. He will present his main findings. This will be followed by a discussion with North Rhine-Westphalian Member of Parliament Alexandra Gese, Werner Steng from the Cabinet of the Commission's Executive Vice President Margrethe Vestager, and Dr. Tobias Schmid, Chair of the European Regulators Group for Audiovisual Media Services and Commissioner for European Affairs of the German Media Authorities. The discussion will be moderated by Eva Flecken, who is Director of Medienanstalt Berlin-Brandenburg. Before I wish us a fruitful exchange of views and hope that we will soon be able to meet again physically under more or less normal conditions, I want to hand over now to the Head of the State Chancellery, State Secretary Nathaniel Leminski, for his welcome address.
Dear Mr. Stein, dear participants, I wish to welcome you here from Düsseldorf. Digitization is connecting us. By that, I not only mean the technology that today hopefully overcomes more than just geographical distances. By that, I also mean the topic of the event today, which I consider to be one of the major and trend-setting current European projects. It's about the regulation of digital services and digital markets. The European Commission has presented very ambitious legislative proposals. It is about nothing less than fair competition, the effective fight against illegal goods, services and content, transparency in the use of recommender systems, and algorithms in the appropriate accountability of gatekeepers. These goals are all to be welcomed without question. This is against the background of developments that have occupied us intensively in recent years in terms of media policy. In this context, we have already found answers to many media policy questions with the State Media Treaty of the Federal States of Germany, which came into force last year. It ensures fair conditions for old and new players. Intermediaries and user interfaces are made responsible. It creates transparency. And it also ensures media diversity through rules on non-discrimination and findability of democratic relevant content. The focus is clear: ensuring free opinion forming, independent media, and the greatest possible diversity, in line with the special characteristics and needs for our media landscape here in North Rhine-Westphalia, here in Germany. The media are both a cultural and an economic asset. This recognized dual role also applies to those who transport opinion-relevant content. They are important distributors and nowadays often gatekeepers for diversity and information exchange. From the perspective of media policy, we therefore critically examine the proposals from Brussels. As in terms of content and structure, they affect partly directly and partly indirectly the guidelines and structures that have been established for good reasons under national responsibility and competence. From the point of view of North Rhine-Westphalia as a media location, as well as the other federal states, necessary measures such as those in the State Media Treaty must continue to be possible. Media supervision and effective law enforcement must live up to the principles of independence and distance from the state and respect the cultural diversity of the member states. With regard to the DSA and the DMA, I think we therefore need, first, clear regulations. Secondly, caution where the chosen horizontal approach affects the freedom of the media. And thirdly, a clear demarcation of the spheres of action between Brussels and the member states. A reasonable interlocking of national and European structures does not exclude this, quite the contrary. The purpose of today's event is to take a closer look at the interfaces. The interfaces between the proposed internal market rules on the one hand, and in particular diversity protecting measures as an expression of cultural identity on the other. In this respect, I'm particularly looking forward to the results of your current study, Professor Dr. Kohl. I also look forward to the subsequent exchange on this from the perspectives of the European Parliament, the Commission, and the media regulators. I'm grateful that we have 3 highly skilled experts for this, who are closer to the current projects than almost anyone else. Thank you for being here today. All that remains for me to conclude is to wish you a good and fruitful discussion. This event might take place at just the right time to provide an impetus for further work on this European project. Thank you very much.
Thank you very much, and a warm welcome from my side. Dear State Secretary Leminski, dear Mr. Stein, thank you very much for putting the DSA and the DMA on our agenda today, and also for hosting this important discussion. Mr. Steng, Mrs. Giese, Mr. Schmid, Mr. Kohl, warm welcome to you, and of course to everyone else who's, I hope, in front of their screens and can hear and see us, but we will soon find out, I guess. Let me briefly introduce myself so you know who's speaking to you. My name is Eva Flecken. Since March, I'm the head of the Media Authority Berlin and Brandenburg, and therefore I am one of 13 colleagues Tobias Schmid has. I'm sure is happy to have. And thank you very much that you allow me to host this event today. State Secretary Leminski pointed out the importance of ensuring independent media and media pluralism. And I'm happy that we take the time today to talk about this. For this, he said, it is necessary to respect the cultural diversity of the member states and to ensure independent media supervision. Well, I agree, as you can assume. I am sure that our next speaker will pick up on this. Professor Kohl is well known and a real expert when it comes to communication and media law and also to competition law in that field. And the Media Authority in North Rhine-Westphalia has recently commissioned, as it was already mentioned, and published Professor Kohl's study, Updating the Rules of Online Content Dissemination. Thank you, Professor Kohl, for taking the time to enlighten us today regarding the legislative options of the European Union and the Digital Services Act proposal. The stage is yours.
So, thank you very much, Eva Flecken. Thank you, Tobias Schmid, for giving me the opportunity to research. I have two screens on, that's why I had to, for a moment, check which button I have to unmute, but now I think you can hear me well, and you should be able also to see my slides, which I will be using in the course of presenting the findings of our study. I'm happy to see that some members of the audience were already in the conference which I hosted this morning, where we talked about the developments on European media law level since last year. And Renate Nicolai, head of cabinet of Vera Jourova, vice president of the Commission, gave an overview of the activities of the European Commission. And I'm happy to say that, well, happy to say at least it will keep us busy besides what we already have on the table and what we're going to talk about today. There's more things to come. Some of you know the Media Freedom Act. So I think we certainly are at a crucial point of time, as has been mentioned in the introductory words. And I would like to focus today on purpose only on the Digital Services Act proposal, because I think already in there we have so much that we need to deal with before it gets into the final stage that we should focus on one after the other, a little bit like when you have a salami, you take one slice after the other, even though at the end it all somehow fits together. So having said that, the topic of today is the dissemination of online content. How online content gets disseminated online, but also how the regulation is on that. And the Landesanstalt für Medien Nordrhein-Westfalen gave the EMR the opportunity already in 2019 to conduct a study to kind of assess the status quo. Where do we stand in terms of cross-border dissemination of online content? We had events on that where we presented the existing legal framework, a focus on the European commerce, the e-commerce directive of the European Union, the interplay of liability regime and other sectoral laws, and basically to identify shortcomings in that framework. And the idea of that was to highlight the key points that need to be considered if the EU decides, as was already announced then, to tackle the question of online content dissemination with a revision of the legislative framework. Because always remember, the years before we saw a lot of developments on the digital single market, but all of it didn't touch the e-commerce directive. So in 2020, we were asked to conduct a follow-up study to go into more concrete terms how to update this legal framework from my perspective as an academic. And we presented the results at an event in October at the Safeguarding Freedom, Stabilizing Democracy event. And there we basically once again reinforced the findings of the previous study, but then we went into the legislative options that exist on the EU level, and we underlined how important it is that this question is tackled now, because we are seeing a development on the platform economy that simply doesn't allow us to rely any longer on the e-commerce directive and the setting of it, which was 20 years ago in a totally different world. One of the points that we try to emphasize in the study, and which will be a topic of today in my presentation, will be that if you approach the question of online platforms with a horizontal legislative framework, you nonetheless have to consider the specificities of media, or the needs, if you want, of the media sector. I will elaborate on that further. And certainly I got a lot of supportive comments, I think, last October when the DSA proposal was not there yet. So what we did after the DSA proposal was launched in December 2020, we updated this study and very carefully tried to analyze the approach that the Commission chose in the DSA, partly also in the DMA, although we focus on the Digital Services Act and not the Digital Markets Act proposal. We then assess each of these chapters of the DSA proposal based on the findings of our previous studies. And then we also proposed some points for improvement. And obviously today I'm curious to hear afterwards of the discussants what they think, where do we stand in the legislative procedure, what will maybe still change compared to what the Commission originally presented. So there's two books, both of them are available for free download at Nomos Publisher. The one of today that I'm presenting is basically the launch event, will then be made available to all of you after the link, so you can find it. We will focus on the latter, and I want to give you a brief look into the table of contents, just so you know what we've covered. Obviously, besides giving the background of the study and really summarizing very, very briefly the applicable legal framework, which I think is very important because we're never allowed to forget the DSA proposal is not going to remove the existing legal framework that applies to the online sector, to the audiovisual media services sector, but it will complement it. Then besides that, we talk a little bit about the problems that exist in the sector or in the field, and then we dissect the Commission proposals. And we do that by focusing on 6 different elements, which I've highlighted here, and which will also guide me through my presentation today. And for each of them, we first do like a state-of-the-art analysis, a starting point. We give the overview of the DSA approach, where we interpret a little bit the provisions that have been proposed, and then we assess them. So the same 1, 2, 3 division we do for each of these points. I will do that in a summary overview first, and then I will highlight some specific points to be considered for each of these 6 areas: regulatory approach right up to the supervision structure. So in terms of the regulatory approach, if you compare the current e-commerce directive framework with the DSA proposal, it used to be a directive. The proposal, as we just heard in the introductory statement, is a regulation, and that is maybe the very first thing we need to discuss intensively in light of the fact what this means for member states' possibilities in the transposition. If it's a regulation, it's directly applicable. It takes the approach of allowing lex specialis, meaning more specific rules, to continue to exist where sectoral legislation pre-exists or will exist in the future. And it takes a horizontal approach. So far, so similar to the ECD, except for the fact that it's a regulation. The country of origin element, or the principle of the country of origin, is kept also in principle in the DSA proposal, but there is a clear shift, maybe a much needed shift towards a more market location approach, at least for several areas. And there are much more reinforced cooperation mechanisms when it comes to cooperation between the regulatory authorities of the country of origin and the countries of destination or of market location. When it comes to personal scope, the old ECD, the e-commerce directive, only relied on the technical regulations directive when it comes to the definition of what information society services are or were, and that definition still exists. In the liability privilege regime, it introduced the notion of 3 different types of such information society services, the so-called mere conduits, the caching, and the hosting providers, and they are now actually separately defined in the proposal of the DSA. So they're not only mentioned in the liability privilege regime, but they are defined, and they include so-called online platforms. That's relevant because I will come to that later. Online platforms are specific types of hosting providers. What is new is that the expression of neutral is introduced. These intermediary services, the idea is that they act neutral, and if they do so, then they can profit from certain liberations of the rules, for example, that they are not to be held liable. Previously, there was more a distinction between active and passive, and it's not yet quite clear whether active and neutral is a very different distinction than it was active and passive. The liability privilege, I will explain later a bit more. So basically the idea that passive information society services should not be held liable, and that member states, when they impose certain duties of care, are not allowed to introduce a general monitoring obligation. That idea has not only been kept in the DSA proposal. What actually has happened, it has been cut out of the ECD. That's at least the idea, that it will be transferred from the e-commerce directive, which otherwise stays in place, into the DSA regulation, and is more or less upheld in the same words, including the prohibition of general monitoring that member states are not allowed to impose on such platforms. But it is added by a so-called Good Samaritan clause, or you could call it that, a clause that is supposedly to ensure that there is legal certainty for platforms which investigate on their own behalf, for example, illegal content and remove it, that this type of investigation doesn't automatically lead to them becoming active or no more neutral and therefore losing the liability privilege. And there is also a specification on how platforms have to deal with so-called legal orders that are issued by authorities, for example. What is new? Total new is that before the e-commerce directive had only very few general rules, some, for example, on spamming, but really very few and mainly relied on specific sectoral law where that was applicable. The DSA proposal introduces an added layer of general obligations which are independent of the question of whether or not a platform is liable. I will get back to that later. And then when it comes to the supervision, the ECD framework was, again, very basic. It relied on the national regulatory authorities. There were certain cooperation bodies which could also be active in the context of the e-commerce directive, even though they were not set up for that purpose, such as ERGA, such as BEREC in the telecommunications sector. But all of those stem from sectoral law. And new in the DSA proposal is that we still have the national regulatory authorities, but we have the so-called new digital services coordinators, which can be existing authorities, which are nominated by the member states as basically the one-stop shop to deal with all of the questions around the DSA proposal or the future DSA regulation. And then we have the European Commission, a very, very important position, at least if the proposal stays as it is, and different types of cooperation mechanisms that are introduced. So, in a little bit more detail, each of those points. I will briefly explain why each of them is relevant for the media, and then what requirements we have in light of fundamental rights. And then I will ask questions. And the questions that I will ask basically indicate where I see the need for revisions or for discussion during the legislative procedure now. So although they're formulated as questions, you can basically see those as my points that I want to highlight where we need to still look a little bit closer into the DSA proposal. So why does it matter what regulatory approach we take, whether it's self-regulatory, whether it's co-regulatory, whether it's a directive or a regulation? It's simple. The media, the content made by media or content that is similar to media content is disseminated today, as you know, online, and not only as well online, but very often it is the main way of dissemination reaching the audiences. So that makes it very relevant. But also the intermediaries that are addressed by the DSA, and by the way, also by the DMA, are a part of the online content distribution chain. In some cases, they are the essential part of the online distribution chain. Keyword in that would be gatekeepers. And that's why if you regulate intermediaries, you automatically also impact the regulation of how this distribution chain looks like. And that's why it is relevant for the media what shape this regulation takes. In terms of fundamental rights and value, so what we need are clear, efficient rules. Efficient, what do I mean with that? Efficient to effectively fight illegal content. And that should happen with an alignment with the existing legislative network. We have already so many legislative acts, transpositions in the member states. They cannot be just ignored. The DSA has to play, even though it's horizontal, a role in bringing those together without contradicting them. What are the challenges in terms of the regulatory approach? Well, one of them we have already heard, that's the question of what type of instrument was chosen. But I would like to focus on, is the interrelation of the DSA with the more specific sectoral legislation really clear enough? Is it enough to just say that the DSA leaves without prejudice these sectoral legislation pieces in place? Or are there not some overlaps which may create tensions in the application if it is not changed, or if it is not made clearer that these sectoral laws actually have primacy or are predominant? Does the DSA leave sufficient room for specific rules that either exist already or might be introduced in the future? I would say now disinformation, but also pluralism, protecting provisions which aim at public interest, and could be done both on EU level, where there are competencies for that, or on member states level. Not sure that DSA is not too broad in a sense in that context. And is the very neutral or the very undifferentiated approach that the DSA takes, being a horizontal piece of legislation, really sufficient to take into account the differences between media and other dissemination, for example, on marketplaces for products? What about the country of origin principle, or how it was updated? Again, I don't have to emphasize why this is important for the media. The country of origin remains a cornerstone, not only in the ADMSD, but also in the ECD and in the future DSA proposal. The question is important how this is dealt with in future, because it is key for deciding who enforces how, which regulatory authority, which member state is in charge. Again, here it would be wished that we have clear procedures on how and when you can tackle non-domestic content. That means content spread by intermediaries, even if it's not their own content, especially when it's illegal, but also when it is seriously harmful. Because what we've seen in the past is that we have sectoral legislation that allows exceptional deviation from the country of origin, but the way the rules were set in practice means it was hardly possible to actually use those exceptions. Is the move towards a market location principle in the DSA sufficient in terms of the scope of the DSA, as well as how the enforcement rules are set to really address all providers that pose an actual threat to the EU market, to citizens and their rights? Or is it maybe a problem that some addressees, potential addressees of the DSA are exempted because they're very small, for example, platforms, even though they could still be dangerous? Dangerous, please, in quotation marks. Is the genuine link, the substantial connection, as it is mentioned, to the EU sufficiently clear that everyone knows, has legal certainty when a platform in this sense is actually addressing the EU market? I think that is already quite well developed, but could also be worth revisiting. And that is the most important for me. If we mix country of origin and destination, which I think is the right way to do, then we have to be very, very clear that the cooperation between the authorities that are involved works in practice, because otherwise we have a clash and maybe through the holes in the net fall exactly those platforms that we want to reach. What about the scope of application? I can do that relatively brief. The scope of application, again, it's relevant because we have several pieces of legislation where we have new types of online platforms that are addressed. For example, in the Audiovisual Media Services Directive, we have the VSPs, the video sharing platforms. In the DSM, we have the Online Content Sharing Services Providers. In the DSA, they might also be covered, the same ones, some of them being very large online platforms, the so-called VLOPs. So we have to make sure it's not only relevant, but how it plays out in practice. Again, clarity of rules, I mean, that's always the case, but clarity of rules here is important for the content intermediaries and also the gatekeepers, that they know under which of these elements do they fall and why are they covered by which rule. What are the challenges here? Being a regulation, I'm not sure. The regulation per se will have a stronger force probably than the existing sectoral specific directives, because the directives are transposed. And so there might be a clash in that context. Once again, a reason why one should reconsider not to make it a regulation. Are the clarifications with regard to the neutrality, what I mentioned at the beginning, clear enough? Would it not be better to more clearly say when platforms are non-neutral or active and can become liable? And is the approach of the DSA, the original idea, what is illegal offline should also be illegal online, is that still reachable if we have this graduated obligation system where some obligations only apply to the really very big platforms? The liability privilege regime, as I told you, has been more or less transported unchanged. Is that sufficient? Is that sufficient, or should we not have a clearer assignment of responsibility to the platforms, considering how much the online environment has changed and how much it has converged as well, where it's no more so clear what is a content disseminator versus other types of dissemination. I think that the threats that we have identified in the previous studies as well for the fundamental rights and values call for a very clear assignment of responsibilities of the platforms. My impression is even that some of the platforms would be happy to know what exactly their responsibilities are. And the DSA approach is to add obligations besides the question of liability. But the question here is, and I'm not suggesting that this is the wrong approach or that should be totally changed, but I think we have to be very clear that, for example, not matching the obligations could lead to losing the liability privilege. Otherwise, the liability privilege will continue to work as a kind of a hiding shield, and that is certainly not what we want. And the fact that they are clearly separated, even into different chapters, we have the liability and then we have the obligations, there is interplay between the two of them, and I'm not sure that whether they have sufficiently been worked out in the proposal. Finally, the Good Samaritan clause, the idea that platforms can act without losing the liability privilege immediately. I don't really see the urgent need to have put in that clarification, because until now, I don't see that platforms have been strongly confronted with liability claims just because they try to contribute to fighting illegal content. At the same time, it's probably also not harmful to have it in. And the content, the obligations for the content intermediaries, and then I'm coming close to the final section about the supervision. Why is it important that we clarify the meaning of these new obligations? Now, I think that is probably the most important development in the DSA. That the DSA acknowledges, okay, the liability privilege regime, or the liabilities, if the privilege regime doesn't apply, alone are not enough to clean up a little bit the online space. We need additional rules, additional obligations. And that is true for many reasons, because the intermediaries, whether they want or not, they have a significant influence on the content dissemination. Not their own content necessarily, but the dissemination of content by others. And that's why this is the chapter that has to be looked at most intensively. Is the comprehensive list that currently is in the DSA of due diligence obligations in line with the existing sectoral obligations? For example, in the AVMSD? So how good do the VSP obligations that are mentioned for member state transposition function in relation to the ones in the DSA? Does the graduated approach that exempts for certain parts the small and micro enterprises some obligations that only apply to very large online platforms, is that really appropriate, or should online platforms more generally, the ones that are involved in content dissemination, be allocated with responsibilities? There I would suggest to furthering the obligation compared to the current proposal. And the central element is the notice and action mechanism in conjunction with the trusted flagger. We can maybe go into that a little bit more in the discussion. There, for example, I find it remarkable that trusted flaggers are not prominently the authorities, because the authorities that are involved in content monitoring, so to speak, for example, in the traditional broadcasting sector, so for example, the ones that are convened in ERGA, are the ones that do that all the time to flag where we have problematic content, and they should be the prime ones to continue to do so. And that brings me to that, the design and structure of supervision. So what we need is an effective and right-preserving supervision and enforcement. Against whom can which NRA take action on which legal basis at all, or to what extent, and with which means? What I mean, all of the elements that I've just mentioned are connected to the question of enforcement. We can have substantive rules with inefficient enforcement. Makes no sense. We've had rules in the past which have not been applied because we didn't know how to deal with cross-border elements. So personal scope, we need to clarify. Is there something below editorial responsibility, curation, mediation, and what does that mean for responsibility? What about territorial scope? When can an NRA act against a non-domestic online platform? What about the substantive scope? Are AVMSD rules, which are still in transposition now, the reformed AVMSD of 2018, are they going to survive the DSA? They should. Liability regime, once again, is it clear enough who is active or who is neutral? And the general obligations, what are the NRAs supposed to do? What is their role in the setup? What do I mean with that? Is we have to ask ourselves the question of the structure of supervision and the procedures in supervision. We need very clear allocation of competencies for regulators that have kind of a media DNA, that are media NRAs, in my view, at least when it comes to content dissemination. Because a cartel authority does not have the DNA to deal with this type of monitoring of content dissemination. However, when we come to that, we are close to the question of fundamental question of division of competencies between the EU and the member state level. And in principle, the member states are in charge of that, and that has to be considered also in the DSA structure, as mentioned, possibly also who gets which role. And does it make sense to duplicate supervision structures if we've just enhanced the supervision structures, for example, under the AVMSD with an enhanced role of the ERGA? I think no. Concerning the procedures on how all of these work together, well, we have to make sure that there is also a form of cooperation in cross-sectoral way. We now have different authorities that could be involved in the DSA implementation, cartel authorities, there could be new authorities created, platform observatories. What role do the NRAs play, the media NRAs that I mentioned? How is the cooperation on national level, but also between the level of EU and member states? In order to make sure that a media-related perspective can be taken into account. And I would also favor a quite strong cooperation mechanism, not very loose, but rather a binding one in the direction maybe of what we can see in the data protection field, but a cooperation between competent national regulatory authorities and not a creation of a super authority on EU level. Finally, a very brief wrap-up conclusion, looking ahead. That's the name of our final chapter. Just to wrap up again, because I've said so many critical things. The DSA and the DMA as a package, honestly, it absolutely has to be welcomed. It's ambitious, it's far-reaching. In my view, it's overdue. It's a regulatory adaptation to the new reality of the online environment, and it has the potential of standard setting beyond the EU. I really think that if this comes in this or a similar form, we will see a similar discussion that followed the GDPR introduction in the EU in the rest of the world as well. Not that we're the first ones, others are also discussing it, but I think it will have a signal to the world, and that alone is positive. But when we review the DSA proposal, please, specific attention to content intermediaries. They've not received an own designation, but they should be regarded as very, very important in content dissemination. Rethink whether or not a directive would be better. Ensure that the enforcement procedures cover also all the new obligations, that is not left to pure self-regulation, but that there is a obligation which can then also lead to an enforcement. Back up these self-regulatory approaches, codes of conduct, memoranda of understanding with enhanced use of what we call industry standards, which are measurable, and audits, but don't rely for the audits only on private sector oversight, include public sector oversight. Strengthen the chosen approach in the DSA to enforcement across border and against non-domestic providers. I would put more emphasis on there, strengthen it, more enhanced cooperation, and make sure that the member states empower the competent authorities and bodies with everything that is needed. Woman power and manpower, but also with the competencies to decide on these matters. And finally, integrate the existing framework very carefully, the one for supervision and enforcement, with the structures that have already existed or just evolving under AVMSD, and refrain from a centralization in so-called digital services coordinators, a very limited relevance of the European Board for Digital Services that is proposed, and putting a very, very strong emphasis on the European Commission, because I don't think that is the answer here, other than it may be the fact for the DMA. Thanks for giving me these extra couple of minutes for my parforce ride along my study, and I hope that there will be an interesting discussion for it. Thank you very much.
Thank you, Professor Cole. Thank you for highlighting possible opportunities, but also maybe pain points of the DSA. I think it gave us, or you raised a lot of questions we are happy to talk about. So now it's time to discuss legislative initiatives, and I'm pleased to introduce our panelists. Do we call ourselves panelists when we are not sitting together? I don't know. But anyway, Alexandra Gese, you have been member of the European Parliament since 2019, and you are responsible for the DSA for the Greens. A warm welcome to you. Werner Steng is member of the cabinet of Commissioner Vestager, and he's responsible for the coordination of digital policy, artificial intelligence, data economy, platform economy, and disinformation. Quite a range of topics, I want to say. Tobias Schmid is chair of the European Regulators Group for Audiovisual, ERGA, and Commissioner for European Affairs of the Media Authorities in Germany. Before we start a discussion, I want to ask you to briefly present your key messages, maybe to raise more questions and point out challenges. And I want to ask each of you to do this within 5 minutes. Please be aware that I'm very German, which means I am rude, and I will interrupt you after 5 minutes to make sure that we have enough room and time for the questions of the audience. Speaking of questions from the audience, please feel free to use the chat also during the introductory statements of our panelists. And now I want to ask Alexandra Giese to start with your introductory remarks. Mrs. Giese, please.
Thank you very much, Dr. Flecken. Thank you very much for having me today to discuss this important matters. I would like to thank Professor Cole for this very comprehensive overview over the DSA, especially over the legal aspects that relate to the media sector. I would like to focus on one very different topic, which is more the economic side and the economic impact that the DSA might have on media. And the other one is that I would like to go back to the ideas presented on enforcement of the DSA, because I think there's still quite a lot of room and a lot of different proposals. To speak about the economic side, Professor Cole said that intermediaries are part of the, we're speaking about the online dissemination chain or online distribution chain, which is perfectly correct in terms of content, but it's also the revenue chain that is extremely important and that might be impacted by the Digital Services Act. And speaking of which, I'm referring to Article 24 that introduces transparency obligations for advertising. And we have a similar article also in the Digital Markets Act. And the rapporteur's first report, the Rapporteur Schaldemose in the European Parliament added to the transparency obligations for online advertising and opt-in obligations. So if users have to actively opt in into the targeting, the personalization of their advertising. And we have seen then when users have a real choice, like, for example, in the new Apple operative system, the new iOS, Facebook has to ask for an opt-in in order to be able to target users with advertising. And more than 90% of your global users, 96% in the US, did not decide to opt in. And that would completely change the whole advertising system. And so this is going to be very interesting in the DSA. I'm quite known. Some of you probably have already seen me on other panels, and I'm advocating for a total ban of targeted advertising in favor of contextual advertising. And I think this is quite important because since the introduction of targeting advertising, revenue of publishers has steeply decreased, while the revenue of Facebook and Google, as we all know, has steeply increased. And publishers have a systematic disadvantage because they cannot, even if they use the same methods, they cannot use the same amounts of data and have the same kind of sophisticated algorithms as very large online platforms have. And when I spoke to media outlets, to publishers, what everybody told me, if you want to change something, go for a total ban and not for an opt-in, because Google and Facebook will always get consent in terms of privacy, because it's very difficult to survive in a modern world without giving consent, especially to Google, but you can easily avoid giving consent to a media outlet. So I'm very skeptical about the solutions on the table right now. I'm also talking quite a lot to advertisers, and we are all seeing the problems of disinformation we're having in our democracy. We're seeing the problems with hateful speech, which are excluding many users from expressing their opinion freely in the internet, which are polarizing our political debate, our political conversations. And I know that a lot of advertisers, especially prestigious brands, are very, very worried about the fact that they are financing disinformation, that they are financing extreme right or conspiracy websites, because with the current system of programmatic advertising guidelines are very often not respected. And I'm not quite sure that transparency will solve the problem, because if we look at how many categories people are being targeted by, and the different kind of targeting done by online intermediaries or publishers, which are very different, or advertisers, which are very different criteria, I really don't see the transparency solution feasible. So I'm quite interested in seeing how this ends up. I also think the article on transparency of recommender systems, so what kind of content we see, is extremely important. And I think this will make a difference. And also the access to algorithmic systems and raw data for vetted researchers and also for authorities in certain cases is extremely important, because we have this huge asymmetry of knowledge between what we know as users and about the platforms and how they work, and what the platforms know about us. And I think this is a very important first step in order to improve the situation. Also, the risk assessments done by the companies, and especially independent audits, are extremely important. But I agree with Professor Cole that we need public oversight in order to make sure that the auditing landscape that might develop is really that the auditing really works, that there is adequate public oversight, and that it's not just some kind of fig leaf that the companies, or especially the very large online platforms, will have. Just a very, I'm running out of time, I realize. Just a very brief point on enforcement. Professor Cole was against the more centralized enforcement. I think it's very interesting, because in the DSA we need competence in media regulation and protection of minors, in consumer protection, market surveillance, antitrust and competition, and data and privacy. And these are all different authorities in the member states, and for good reasons, because you need very different kinds of expertise. And if you multiply this by 27, it gets really, really complicated not to have a huge fragmentation of oversight. And I think this is exactly what very large online platforms are looking forward to, to play one member state and one authority against another. So I think what we lack, on the other hand, is one agency that really has very specific expertise on how very large online platforms work, and they work differently one from another, on how huge data processing works, on how complex algorithmic systems work. And this is where I think we really should have a European agency that has the expertise, able to act to attract very, very competent experts, that has oversight over the auditing of the risk assessments and the compliance with the DSA. And I think this is something we should have on a European level, at least the competence for these aspects, and for all of Europe for the very large online platforms, because otherwise we risk end up with something like GDPR, which is excellent legislation, but as it has been applied so far, I think these things are changing really these days, even on GDPR. But if we can't enforce that legislation, it will not benefit Europe. It will not bring us forward. And we need to make sure that enforcement in the DSA works. Leaving it with the Commission as it is now, we have that very German problem, but I think it's a very correct issue to raise, that we need independent oversight, and the Commission is not exactly independent as we would intend it. So I'm quite in favor of a European agency, maybe with limited competences specifically for the very large online platforms, algorithmic systems, oversight of auditing. Thank you very much.
Thank you, Alexandra Giese. Professor Cole already explained to us why the DSA is relevant for the media sector. I'm grateful and happy that you added a more economic aspect to that discussion. And also, I am sure we will have to talk about the variety of institutions and the question which institution should be the competent one. But first, I want to ask Werner Steng, please, your introductory remarks.
Yeah, thank you very much. Good afternoon, everybody. Also, thanks for inviting me, for organizing this debate, because that's what we need. I'm also very encouraged by the last 6 months to see how this has been, how our proposals have been taken up by the Council, by the Parliament. The amount of interest shown also shows how important it is. Professor Cole rightly spoke about a major reform. This is a major reform of the internet. If you look into DSA, DMA together, it's also the first of its kind globally. So we are being watched, we are setting standards, we're aware of this. We think it's ambitious, it's far-reaching, as Mr. Cole said, which also means that we can never get it right, or nobody ever is totally right in all of our arguments, neither we nor anybody else. But it's so important that we discuss all of this. And that's my first point, because one of the major objectives of the whole package is to regain democratic control, democratic oversight, accountability of the platform economy in its widest sense, because of all the decisions that platforms, good or bad, are taking on our behalf. They are gatekeepers, not necessarily now in the definition of the DMA, but they hold the key to us as consumers, to citizens, what products or services we see or don't see, what type of information or content we see or don't see. So quite obviously, this crucial role that we did not have in the internet 10 years ago, 15 years ago, but now we have it. And that means that someone is taking decisions, and I'm not saying that's always done at bad will, but someone is taking decisions on things that affect all of us without us understanding on what grounds they are happening. This is why, by the way, it's so important what Alexander Gese referred to, the transparency of advertising, of recommender systems, of algorithms, because that is, of course, the mechanism through which demand and supply in all regards is being matched. Now, that, of course, means that private companies are taking those decisions. Everybody else depends on them to share or receive content, to sell or to buy products and services. So private companies whose interests are obviously not aligned or necessarily aligned with ours, which is also normal. They are private companies. But the consequence of this, of course, is that acting under a profit motive, you would try to maximize your profits. That's normal. And that also means, for instance, on disinformation, also what Alexandra said, that it's more important that content is being shared and seen and clicked at than making sure that the most appropriate content is being pushed. Also, the double role, of course, of many platforms that are not just intermediaries, but also act on their own platforms, naturally means that there's an incentive to use the power that you have to favor your own services. But that's very much the objective of the Digital Markets Act. My second group of comments is linked to enforceability. And here I don't only mean of the DSA, but of all of our laws. And that was a major driver also behind the DSA, because what is illegal, that has always been pretty clear. We have laws in place on many areas. We know when a product is unsafe and not allowed, when it's counterfeit and not allowed. We know what illegal hate speech is, what a copyright violation is, and so on and so forth. The problem has been enforceability. And that was due, on the one hand, to the opacity of the internet, to this disintermediation that we have seen, that you have no longer the traditional chains, but that you have platforms based on algorithms that connect A and B, and nobody quite knows how and what and with whom. It's very hard to get in and enforce existing laws. And then we had this cross-border dimension on top of it, linked to the e-commerce directive. What is the role of the host country, the home country, who has what type of responsibilities, and so on. We try to address both issues in a way, because through the substantial rules, if you want, the due diligence obligations that have already been mentioned repeatedly, we're trying to make sure that the platforms act more responsibly. They have clear legal obligations to make their platforms safer, more transparent, more respectful of our rights, including fundamental rights, freedom of speech, and so on and so forth. So clear due diligence obligations. The transparency around this is also meant to help anybody else to see violations of existing laws and prepare the ground actually for proper enforcement. Then we need the mechanisms to make sure that national or EU laws can be enforced. And this is where that's not about enforcing the DSA, but it's enforcing laws. And the DSA helps here. It gives information, it gives powers to authorities. It enables us also to punish platforms that systematically do not comply with those due diligence obligations. As a consequence, you can expect that illegal activity goes down as well. And then we come, that's my last point, to this to the enforcement of the DSA itself, where, as also Professor Cole alluded to, we have put in place, we think, a very powerful cooperation mechanism there. A clear responsibility on the home state authorities to make sure their platforms comply with the due diligence obligations. But if then the host state or the marketplace or whatever you call it thinks that this is not properly, the job is not properly done, and we had this criticism in the past, we have a clear escalation mechanism involving the Commission, involving all the other member states to sort these issues out. So in a nutshell, we think this is the right thing to do, to bring in responsibility on behalf of the platforms, a lot of transparency around everything they do, and very powerful enforcement structures. And I'm happy to discuss the details in the following discussion.
Thank you, Mr. Steng. If I may quote you, you pointed out that we are working on a major reform of the internet as such, maybe. So I think we are all well aware of the major challenge we are facing at this point. Last but of course not least, I want to ask Tobias Schmid for his introductory remarks, please.
Thank you very much, and welcome everybody. Indeed, as I'm in the little, how to say, complicated situation that I'm not only panelist, but also a little bit responsible for this happening. First of all, I would like to give my thanks to Eva Flecken, because she took over the moderation of this event, and without her, we wouldn't have a chance to do so. So, of course, also thanks to my colleagues in Brussels and NRB and NRW, and of course to all of our participants. And now my keynote starts, my key position starts, and the 5 minutes. So I think there is a very common understanding of all stakeholders that the DSA and the DMA are extremely important steps done by the European Commission to, how to say, to secure freedom in the online world by implementing rules. And I think there is support from all sides. And I'm also sure that the European Union is the right one to do so and to bring these ideas into the international discussion. And here the European Commission has the full support of the European regulators organized in ERGA, and as well as the German regulators for media. So everything okay? Could I stop here? Maybe I would like to change the perspective just for a second. Imagine a platform on which video glorifying violence can be found. Or imagine another platform where you can consume hardcore pornography. And now imagine a little 10-year-old girl or boy watching something like, for example, Kikaninchen. This is a German channel for kids. And then just by tapping the tablet screen, reaches the unsecured page of this platform. So what does this do to a little person, and what does this do to a society that does not prevent such things? You know, these cases are our reality. This is the reality of media regulator we are facing day by day. Just to give you a number, in the case of Rhine-Westphalia, just one German state, we have about 120 cases a month in the online world. We are getting active. And it is our duty to find solutions and to make sure that also in this connected world, we can generate an environment where even the smallest can grow in, how to say, in an child-friendly way in an online environment that is respecting human dignity and other points like this. To act against this violation of values and law, we have rules. As Professor Kohl said, and also Werner Steng, we have national media law, we have the harmonized rules coming from the AVMS directive. What we also already have is a strong structure of collaboration. We have a collaboration on European level in between the media authorities. It's called ERGA. It was an idea of the European Commission and a good one. So there is already an existing structure. And we have a very good and increasing collaboration on a bilateral base. Because the cases I described to you are normally happening in between two of us, either in one country like Germany, or for example, between Germany and Cyprus, between Germany and Ireland, or others. For this constellations, we have already structures. What we not have, and there I agree to the points of Werner Steng, is an effective law enforcement system. And that leads us back to the question, is everything good, or is there a need for improvement also for the Digital Services Act? And I think the answer is yes, because we as regulators, we have, it's not so much, but we have 4 or 5 points, I think, where it could make sense to have a closer look on. The first is, as Professor Cole described, the question of liability in between the different actors we have in the online world. You know, this is one of our main problems, to have a very clear understanding in which periods, which part of the supply chain is responsible, is liable. The second is, and this is really important, I think it's addressing Article 12 of this draft, is we have to have a clear priority of national or European law in relation to the terms and conditions of the platforms. And I think it's an historical chance for Europe to take the DSA and to make clear that we have now again a situation where the legislative institutions like the parliament is setting the rules and not the industry. Then we need, and this is also not so complicated, but I think it's it would be extremely helpful. We need regulation with the possibility of execution. If you take, for example, the Articles 8 and 9 of the DSA, there you have, for example, the idea that we could ask for information. Okay, but what happens if we don't get it? You know, I can already now send a letter to Facebook and ask for information. This is not an increase of the competences of an authority. And then I would like to come to the other point. I think, you know, what we do not need is an additional complication of the governance structure, because, as I said, we have already existing structures. And this is why I would like to come to this last point. We ask the European Commission and the Parliament to have a closer look if it could be a good idea to implement the existing structures like ERGA and BEREC in the idea we have here, because I think we should differentiate between the question if we have cases in one sector, for example, the audiovisual media sector, or if we have indeed questions where we have, like Alexander Gese described, situations where you need a lot of different perspectives. In my experience, I'm doing this job since about 4 years. In 98% of all cases, it's audiovisual media. And I need a very fast procedure to protect my citizens. I've got to call my colleague in Ireland and solve the problem. What I do not need is to go to a digital services coordinator who goes into a digital services board and discuss with 26 others if we now could do something against violation of the protection of minor rules that we have. You know, I see the problem and I see a need for this digital services exchange and board, but in the practical experience from a media regulator, I've got to say, as I said, 98% of all cases are extremely, how to say, time critical, and we have procedures in between us. And this is something that we can solve very fast. And the main problem that we here have is to find simple rules of procedure and not more complicated. And the last point, of course, as also Mr. Leminski said, and we've heard from others, is as regulator, we have got to ask for securing our independency from state influence. So nearly 5 minutes, I think. Thanks a lot for the attention, and back to Berlin and Eva Flecken.
Well, it was 7 minutes, but I think that is okay. Thank you very much. This really brings me in a difficult position. Actually, I want to discuss with you, but my job is to ask questions, and I will try to do that. Since all of you three pointed out or raise questions around the effectiveness of law enforcement and the structural questions, also something Professor Cole highlighted in his statement. Maybe we stay at this topic for just a little longer, and I want to ask Alexandra Giese, do you see today, I'm talking about today and the current regulatory obligations and the current regulatory setup, a lack of executional power when it comes to cross-border law enforcement, or are the European regulators in general well equipped and they know how to do their job, as Tobias Schmid tried to explain what he's doing on a day-to-day basis? And my question is, if so, if you think, yeah, well, in general, they're well equipped and they know how to handle their cases, what would change with the DSA so fundamentally that we would need more like a one-stop shop regulatory body, as you proposed in your statement?
Well, I think what changes is that we have a lot more obligations, especially on the very large online platforms. I think that is very clear. I think Werner Steng pointed that out very clearly. We have all the obligations, the beginning of the DSA, that have to do with notice and action and illegal content and so on. We have the due diligence, we have the transparency obligations for advertising and for content with recommender systems, the risk assessments and so on. So there's really a host of articles that impose new obligations on the very large online platforms, and that might be very, very impactful in order to improve our internet, make it safer, make it more democratic, and give media more possibilities to compete and to find a better role in this online dissemination or revenue chain. But they need to be enforced. And I'm actually not seeing this right now in the landscape we're having, and I think we will need quite a lot of European cooperation on this. And as the DSA is setting it out right now, it still gives a major role to Ireland. And as everybody who is following GDPR implementation knows, Big Tech is all headquartered in Ireland, basically the ones that are relevant for our conversation here. And at least the Irish DPA is not particularly well staffed or prepared to enforce, in that case, GDPR. And we don't have any reason to believe it would be different with the Digital Services Coordinator. So the Commission recognizes that and introduces a complicated mechanism. And in the end, the decision ends up with the Commission, which is a good thing in order to avoid the lack of implementation in the DSA. But then we have the problem of independence that has been raised several times, and rightly so. And this is why I would prefer to have, at least for the very large online platforms and for those obligations that are not covered by currently existing authorities, or not correctly covered, extensively covered, like, you know, how do you audit Facebook? I mean, this is a question nobody can answer right now. Which aspects? How do these algorithmic systems work? Who really has the expertise to look into an online advertising system? I think there a European agency would be very important to avoid that European member states might take different decisions, or decisions are delayed in Ireland or later with the Commission. I mean, we know there's a lot of political influence, there's a lot of lobbying as well, and I think to have somebody that has more expertise and more independence would be very helpful.
Werner Steng, maybe you want to add something to that. I mean, working for the Commission, I'm sure you are not eager to comment on one or two member states, but I'm sure you have a very broad and good overview about the cross-border activities and cross-border law enforcement in general.
Yeah, indeed. Let me come back to your basic question, what is happening now and what will change in the DSA. And here again, I would distinguish between individual instances of some illegal content popping up in Germany, not being in compliance with German law, any German law, and more systematic failure by platforms to act responsibly. Now, today, if you want any more systemic problems, is complicated. You know, there's a cooperation procedure in the e-commerce directive, and you try to phone up your Irish colleague and tell them, oh, this platform always does this, that, and the other. And then there were some complaints about this not being effective, but also, to be fair, there were often not clear rules to be enforced by the home authority in the first place, because we did not have those due diligence obligations that now will be in the DSA. So maybe a lack of willingness, but also sometimes a lack of rules to be enforced, and the lack of enforceability of any rules, because this was been missing as well. When it comes today to individual items of content, right? Tobias and friends find that there is some illegal content in popping up on Facebook in Germany. Already today, of course, a court or an authority can order and prevent, can order a termination or prevention of an infringement. That's already clear in the liability framework that you can always do this, right? The court goes in and says there is illegal content on your platform, and you even have to, you can even have a stay down obligation. We had this for products, but we also had this for hate speech, for instance, in Austria, my home country, the Klawischnik case, for instance, where she was insulted. And then the court said, yeah, even a stay down obligation is feasible because there would not be a general monitoring obligation, but very specific. Nobody else can insult her again on the same grounds. So that already was possible at the time and will be possible in the future. The liability framework as such, I feel, was not very powerful because it was so indirect. You know, as a platform, I risk losing my protection in the safe harbor if I don't act expeditiously. But still, that is only for one item where I'm getting notified. And if I don't act, then someone has to take me to court and then prove, first of all, that I had done something and had created harm, but also prove that I had not been acting upon it. That may take ages, and it's just one individual case. This is why we prefer the current, in our proposal, the system where all that exists today will keep existing. But on top of that, you have the enforcement possibilities for systems non-compliance. So that you go in and say, to answer one specific question of Tobias, by the way, you said, well, what if Facebook or anybody else does not respond to our information requests? We can already send them requests today. Well, if they don't, the whole enforcement chapter of the DSA kicks in, both for the member states within their competence and for the very large platforms for the Commission. You go in with systemic non-compliance with the due diligence obligations, and one of them would be to respond to your information requests, to act upon your removal orders, to act upon allegations that you don't know your business customers and so on. And then, as you know from the proposal, of course, you can do anything from ordering them to stop doing so, imposing fines, adopting interim measures. You can actually even ask them to be shut down on the internet if all the other measures have not borne fruit. And you can also sanction them for 6% of annual turnover. So we think that would be much more effective in a way in ensuring that systematically platforms will act more diligently than just being threatened by individual instances of liability.
I can see that Tobias Schmid wants to answer to this. I think otherwise I get kicked off this call. But maybe you could also do this with special regard to ERGA.
Yes, of course, and thanks for that. I try all the time to have in mind or to take care of the ERGA position, and as you can believe, it is very interesting also to have this internal discussion because the organized regulators in ERGA also have very different structures. We have convergent regulators as well as separated. But the points I'm underlining here are our common understanding. And I come back to this point in just a second. First, I've got to make a little, half serious, half joke comment to the point also coming from Alexandra Giese concerning the effectiveness of European and central institutions. Just to bring this back in mind. The main problem in the last 3 or 4 years that we have had with Ireland was that our Irish colleagues doesn't have a clear competence to intervene in the online environment around the harmonized rules of the AVMS directive. And what was the reason? Ireland has already until now not implemented the AVMS directive. And who is responsible to take care for implementation? I'm not sure, but maybe it's one of the central organizations we have in Brussels. Just to make this very clear, you know, I'm blaming no one, and my Irish colleagues are working very hard on that. But the main problem was set up because the central institutions in this function hasn't had the effect that we needed. So that's just to have it in mind. That's my personal opinion. Of course, that's not an ERGA opinion, as you can believe. But at the end, it's not an opinion, it's a fact. So I come back to the question, you know, I think, and this is, I think it's also an important point we have had in the ERGA discussion. And I like this point that Werner Steng made to say we've got to differentiate between cases where we have individual, violation of law or systematic issues of the platforms. And I agree. And I think almost every one of our colleagues would agree. You know, but I'm just a German, I'm just a lawyer. And that's why my question is, okay, but if we have so many questions to that, could we make it a bit clearer in the DSA draft? You know, if it would be very clear that this area of so to say, day-to-day violation, for example, in one sector, like the audiovisual, is still up to the existing structure, what absolutely would make sense because it doesn't make to destroy something that works, then I think a very strong part of our concerns or fears would be done, because that we need another view to the more systematic or the systematical mistakes or faults or problems or issues. There, I think we have a clear agreement. And the second point, also to underline this, we also support, of course, the new measures that the DSA delivers and that makes regulation stronger. And I also believe so. The only question we have is, in which cases could we use it? Because, to be honest, I do not exactly understand the mechanism. Maybe also here we can have work for a little bit more clarity. And the second is, and who is using that? And Alexandra Gese said it in her incoming statement that, of course, we've got to be a bit careful because the European Commission, as far as I can see, one of the best administration bodies I know, but it's not independent from state. So that's why we have got to find a solution. At the moment, the structure, the governance structure is made very clearly so that you integrate a lot of different members and member states, all 27 with the digital services coordinators, but the competences to decide at the moment are up to the Commission. And I just would like to make this clear. And so that's why I'm not sure if we haven't really, if we haven't, how to say, if there is a real conflict. I think we have the same understanding, we have the same objectives, and we strongly believe that Europe is the right body. I think that's my impression out of the discussions I've heard in the last months. We need a bit more clarification, maybe especially in the areas that, that I described. And this could solve a lot of points also from the perspective of my dear colleagues in the ERGA organization.
Thank you. I think we talked about the structural question for quite some time, and I want to give Werner Steng the opportunity, maybe on from a broader scope. What is the Commission's goal in regard to media-related questions with the DSA? I mean, today we talk about the DSA against the background of the study, which is commissioned by a media regulator. And I think we talked, as I said, about the institutional questions for quite some time right now. But when it really comes to media content and dissemination of media content, what do you want to achieve with the DSA? What are maybe your main concerns you want to tackle?
Well, but then one would already first have to say that DSA is not a media regulation, or not all we do on media regulation. Yeah, I mean, it's part of a puzzle of activities in Brussels, each of which has a bearing on the media. And the DMA was already mentioned, obviously, today, but obviously whenever there is competition-related concerns, that is equally important from the media sector than for any other sector of the industry. And lots of the provisions and prohibitions in the DMA will be beneficial for media operators at the same time. We have the self-standing work strand on the European Democracy Action Plan, which also has a strong media dimension, including on disinformation, but also beyond. Then we have the European Media Action Plan, which is also there sort of to strengthen the media sector as such, and also through investments and so on. So just to put this into the broader context, that the DSA did not set out to save the media, but that said, of course, it will benefit the media sector as much as any other sector that is concerned by the current practices in the online economy. So it was said repeatedly also by Professor Cole, of course, this is a horizontal framework. It is also not any piece of content regulation as such, the whole DSA. It's about procedures, as we all know, because we are nowhere are we saying what illegal content is, what legal content is for that matter, right? So we're also not saying what harmful content is, what disinformation is. We're not defining content as such, which is also why we have no must-carry obligations, which is something that the media sector, for instance, has insisted upon in the past. But since we don't say what content needs to be shown, it's also very hard to say what must be shown. We're just saying we want effective procedures in place that anything that is illegal is removed, and we want equally strong safeguards to make sure that perfectly legal content stays online. And the media sector benefits from this in both regards, if I may, because on the one hand, if there is content disseminated on online platforms that illegally appropriates itself of copyright protected material, for instance, and of course it needs to be removed. But at the same time, if content is removed, where now a media operator or regulator says, hang on, how dare you remove that content, all the procedural parts of the DSA are there to protect them as well, and to have, starting from the clarity of the terms of service of what type of content will or will not be shown on a platform, to transparency about the processes, the outcome of content moderation processes, the possibility or the obligation to give then in that case a media operator the chance to challenge such decisions. So just like any other type of sector or economic actor, the media sector is protected in the DSA. But once again, media is being regulated and addressed in many other instances as well.
You just mentioned the removal of content, and there is one question of the audience from Oliver Pribamski, working for the Deutsche Fußballliga. When will expeditious being clearly defined for the removal of copyright infringement? I guess, Werner Steng, this is a question for you, or maybe also for Alexander Gese.
I can start, but I'm sure the other panelists have also comments on this. I mean, this has been an eternal question and a hard nut to crack ever since the e-commerce directive was adopted. What does it mean, remove expeditiously? We have not addressed this in the DSA, as you have seen. It's about sort of instant action by the platform. But we did not now go through a list of 15 different types of content and say, and well, for copyright protected material, that means 6 hours. For terrorist material, it means 5 hours. For live streaming, it means 20 minutes. For a violation of safety procedures, it is 24 hours. And, you know, you see already the problems you're running into if you had to identify now precise time windows for each type of content. And even within those types of content, you would then run into problems because it's very hard to harmonize that even within a group of content, let alone across content. It's clear that it still has to be expeditious. It's also, we try through the trusted flagger mechanism to clarify that if notifications come from a trusted source that has a track record of not being wrong, that this can happen even faster, if not instantaneously, with all the transparency safeguards attached. But if you then want more sector-specific timelines, then you need to go sector-specific. Look again at the terrorist content proposal that was adopted a while ago. That was a very specific type of content where all the law enforcement experts said, for instance, 1 hour is a crucial point in time before such content goes viral and does much greater harm to society. That was examined and proven and discussed and negotiated, and again, subject to very sector-specific safeguards, a solution was found. But we did not find the silver bullet in the DSA, once again, for any type of content.
Thank you. since I used to work for Sky Germany, I'm aware of this topic. So thanks for elaborating on this a little bit. Alexandra Gese, in your introductory remarks, you pointed out the importance of transparency obligations also for platforms and for the new gatekeepers. I think new gatekeepers was a term Werner Steng used. Could you elaborate a little bit on that? What is your view on that? What hopes and I don't want to say dreams, but what expectations do you have when it comes to transparency obligations for those new gatekeepers?
Yes, very happy to do that. I think what is really characteristic of our times is, as I said, the asymmetry of knowledge. We know basically nothing about how those platforms work. We have some anecdotal evidence, we have articles, we have some leaked internal presentations of the platforms, and that is basically it. We don't have any real hard evidence where we can say, okay, this is what an algorithmic system is doing in that specific instance. And on the other hand, the platforms collect huge amounts of data about all of us individually as groups and have profiles on us individual and as whole population groups and whole populations, and sell these currently to advertisers, but in the future and also currently also for other reasons. And I think this is something we have to address. This sounds a little bit philosophical, but it has really a huge impact on our democracy, on our economy in terms of competition, for example, and on our privacy. So I really appreciate that the DSA made that first attempt, asking for transparency for advertising. So users need to be shown, for example, why a certain ad is targeted to them. I already pointed out my criticism. I don't think that's feasible, actually, because the system behind it is so complex and the data is so enormous, the amount of data. And then this privacy issue, what we really want to see in our screen, why we are being targeted. Well, maybe my kid is looking over my shoulder. I think there are issues that where I don't see the solution, but this is maybe very specific. What is also very good is the recommender systems that need to be more transparent. So there's access for vetted researchers in order to find out, and this is Article 31, to study those systems and every aspect related to compliance with the DSA obligations. So that would put us in a situation that different researchers who are experts in different fields could start studying different aspects of how platforms work, of how the algorithmic and gear-to-profit system works, and turn this, give this information to the public domain. What might be interesting to have, and what is not in the DSA, is to have some instance that then examines that kind of information and decides what to do with it. I think maybe if I can bring up one more point, what is a little bit lacking in the DSA is citizens, really, because this is about companies, about in a certain amount about publishers, and about enforcement by authorities. But where do citizens come in? Well, we have legal content, single pieces of content, we have clear rules, and that's, we have judiciary and law enforcement for this, and that's correct. But what do we do, for example, with codes of conduct on hate speech, on disinformation? I know many publishers are quite interested in that. Media professionals are interested in that. So there we have the commission working with the platforms, and there's a lack of transparency, and I appreciate that we have additional elements of transparency here. That are added, but maybe we should have an experts council and maybe even a citizens council to look at what comes out of those codes of conduct. Is disinformation really increasing, or content that is considered going against terms of service or accepted by terms of service, which are private contractual terms on which as users we don't have any influence, basically. And many of the issues we have been discussing about accounts to be blocked or posts to be taken down are not illegal. I mean, if we think of the Trump debate, for example, there was a breach of terms of service of Facebook or of Twitter, but there's no clear illegality. How do we want to deal with that? And I think it would be very interesting to have, in addition to the transparency, in order to assess and to publicly debate the results of that transparency, to have, for example, a citizens council like Ireland has had, like France has had, with very interesting results, in order to speak about what do we really want to see in the internet. And there's a distinction between content that is illegal and content that is harmful. And there's a difference to media. While in media, we have a clear regulation of harmful content for good reasons. In the internet, it's different because we also have to protect freedom of speech. So we really have this gray area that's extremely complicated to wait for a legislator, but where we need to look into further, just as an additional idea. It's not in the DSA right now, but it's something that I would like to see there.
Thank you. I understand we need more research and maybe also new tools for participation, as you mentioned, the Irish Citizen Council. There is one comment on your, I think it was more the introductory remark for you, Mrs. Giese, from RTL, Klaus Grevenich. We very much agree with the findings, economic impact, systematic disadvantage for publishers. But I mean, obviously, RTL does not agree with the possible solution ban of targeted advertising. And therefore, Klaus Grevenich is asking Werner Steng one question. Do you see any chance of leveraging the level playing field towards the DMA platforms through ad tech obligations? Oh, you're reading it. I can tell from your face.
Yeah, I'm reading it slowly. Not entirely sure I fully understand the question. Of course, the thing is that in the DMA, let's start with access to data, because that is something that comes all the time. And I think we have different instruments, different proposals that deal with different dimensions of access to data. Some of them are covered in the DMA, others are covered in the DSA. I think starting with the DSA, it is clear we're talking about access to data that help us understand the impact of content moderation systems, of advertising, of allowing researchers to go in and see, for instance, to what extent ads may have been shown alongside dissemination sites. So that's all part of the second part of the proposal. But also, of course, data access possibilities for public authorities when it comes to enforcing the DSA itself. But in the DMA, you have the much more substantive data access requirements. Those are, of course, limited to what is then really a gatekeeper platform for, according to the definition of gatekeeper in the DMA, so the very, very big ones. But there it's really about data for users of platforms. I'm a hotel, I'm using a platform falling in scope, that I get access to my data that I generated on the platform. You get data linked to advertising, what happened with my advertising expenditure on that platform, and a couple of others. So in that sense, data access is a bit everywhere, but I don't know exactly. Probably Alexandra is already volunteering to continue here.
If I may, Dr. Flecken, yes. I think what Mr. Grevenich or Dr. Grevenich is referring to is access to the data in possession or under control of Google, Facebook, or the very large online platforms, the gatekeepers, according to DMA, the data that is used for targeting ads. I think this is really problematic because I understand where you're coming from, but this is personal data and it can't be easily shared. So I would exclude that very clearly under GDPR. This is personal data. And even if I have strong objections to the way that consent is obtained, I wouldn't go to the lengths to say, well, since consent is obtained in a way that is not obviously at least GDPR compliant, we can just simply share that data with other advertisers or other publishers. So this is personal data and should be protected. I would be against that solution, and I really don't think it's legally feasible.
Thank you for clarifying. I have one more question from one of the participants. I think it is Alexander Scheuer von Deutsche Telekom. He mentions high risks for fundamental rights when it comes to more biting cross-border enforcement across all kinds of intermediaries. I'm not sure, maybe Tobias Schmid, are you concerned about risks for fundamental rights when it comes first talking in when it comes to cross-border activities with other regulators? Is that something this concern you can understand?
That's an interesting question, and it's not so easy to answer. You know, that's a very, and I'm sure that Werner Steng and Alexander Giese will agree, that's a very specific question for the media area. And of course, we know that the perspective on fundamental rights, especially around media, differs also in between member states sometimes. You know, the understanding of freedom of speech is a little bit different. We have not a 100% common understanding also about the topic of disinformation, if you have a look on the member states. And this leads me to again, to the oversight structure at the moment. And I'm really asking the Parliament to have a view on that. You know, if we have a structure where cross-border cases are negotiated, so to say, always in between all 27, this also can be challenging. You know, again, coming back to reality, the reality is that we have, for example, in Germany, clear rules about the usage of symbols of the National Socialistic Party. So that's a very German issue, of course, because of our history. We have rules, and if we have a problem in another member state, for example, in Italy, because you can buy over there the things related to that, then we ask our colleagues in Italy to intervene as long as the German viewers are addressed, and that works. The cooperation with our Italian colleagues, with AGCOM, and as well with others, is working on a very good way. So now I'm not sure if this is meant by the DSA, that's why I'm asking for clarification. But now if this would be in future a case where we have got to discuss this special problem with 27, that wouldn't make it easier with 26 because we are one of them. And so, and also around the area of disinformation. So that's why I think it's really important to differentiate between systematic issues of big platforms with more than the media perspective from the daily business of media regulation, where you have always to have in mind the specific situation in the market, freedom of expression, and singular issues. And these are at the end two different things. And the one thing is already running, and we are just fearing that this is, how to say, as in collateral damage, damaged by this DSA structure. And I'm sure that we can solve this problem. And then I would be also much more optimistic that at the end, the DSA reaches its objective to stabilize core values and not to damage it.
I'm really not capable of multitasking, but I saw that Werner Steng is happy to add a bit on this.
Yeah, because it's a very interesting question about the territorial scope, I think, in particular of the national orders in Article 8, where you can give an order to a platform established elsewhere. And in that case, the question would be, what if in one member state particular content is illegal? What type of order can that member state, the authority, give to the platform? I mean, what Article 8 clearly says is that when any authority or court is sending such an order to the platform, it has to be clear on the territorial scope of that order, which itself is not regulated in the DSA, but that depends on applicable union or national law and the Charter of Fundamental Rights. But still, it also says it does not exceed what is strictly necessary to achieve its objective. So coming back to Mr. Schmid's example, if there is content that is solely illegal in Germany, then the German authority cannot order the platform to remove the content all over Europe or globally, right? Because that would be disproportionate to achieve the objective. But once again, it is subject to national and union law. I just come again with my Klavischnik case example of Facebook, because one of the questions was also, can the court order Facebook only to remove that content in Austria, or could that also be globally applicable? And including the European Court of Justice was not super clear about this, but said, well, it's a case-by-case adjustment and la la la. So if the European Court of Justice was not very clear on how to solve this very specific case of an insult against this Austrian politician, of course, in the DSA, we cannot come with the ultimate geographical scope, but it is very clear it must be proportionate what is strictly necessary to achieve.
Thank you. As Professor Cole, no, okay. As annoying as it is to look into cameras all day, and I think we all feel that, the good thing is those kind of events are a little bit more, well, you can talk a lot in 2 hours, although the networking part is of course missing. I want to thank Alexandra Gese and Werner Steng. Thank you very much. Of course, Professor Cole, thank you. And thank you to the representatives of North Rhine-Westphalia, Mr. Stein and State Secretary Liminski for hosting this event today. And since I know that my dear colleague Tobias Schmid really prefers and likes to have the final say, the closing remarks are his. Thank you for having me today.
Thanks a lot. And yes, I'm very glad that we had 2 minutes before the event ends, because that minimizes one key challenge. The idea of the program was that I should summarize now, and that's very funny because I was part of the discussion, and it was a very interesting and intensive discussion. So I'm of course not as multitasking able as others, and so my summarize will be a very short one. First of all, and I think this is very important, and it's addressing the European Commission and the draft of the DSA. I think again we have heard that the idea of the DSA and the DMA is something that has very broad support. And that also means media regulation. At the same time, as Werner Steng said, the DSA is not only media regulation. Yes, I think we all understand this, but, and this is the perspective we've heard from Professor Cole, but it is also media regulation. And that's why we've got to take care that we have the right balance in between this horizontal approach in general, a good one, and on the specific issues we have in the media environment, as we have heard, so that we do not destroy the values we would like to protect. We have also heard from the state of North Rhine-Westphalia the importance of independence and of specific cultural characteristic in media, and I think that's again the same point. So the challenge to balance out the holistic approach of the DSA on one hand and the interests of the member states on the other. We have heard a very interesting overview from Professor Cole. Like always, it was a pleasure to listen to you, because it's not only interesting to read all the results of your work, but also to listen to the very structured and very impressive way to describe us chances and challenges out of the DSA. I think we have discussed about the structure of supervision, and my impression is that there is some point getting clearer more and more that it is maybe more a misunderstanding than a different, how to say, approach. And if it is so, then this could be getting a bit clearer. Of course, I've learned that from Alexandra Gese that between that we also have got to have a look on the economic effects that is generated in this area. I think in this context also the discussion with our colleagues from RTL was interesting about data and how to proceed with that. Also not an easy point. You have heard that there is not in the same second and common understanding about the question if regulators are able to do their job at the moment, or if we need a European agency for that. But I'm still working for and describing what we are doing. Maybe our work is better than our marketing. That's something we've got to work on. But therefore, we have events like this, and there would be hundreds of other points, like the question of disinformation, transparency. We have learned a lot about the mechanisms and the idea how to enable enforcement. We have heard from Werner Steng the question of change of reality and the fact that we need at the end a powerful cooperation mechanism in between the different institutions. So there is enough to discuss for the next I don't know how many weeks, and I'm sure that it will be also in the upcoming time and very interesting and intensive discussion, and that is a good thing for democracy in total. In addition to that, I would like, before I come to the end, I would like to underline one additional point from Werner Steng, and that's also important. We have got to see this discussion, of course, together with the upcoming projects of the European Democracy Action Plan and the European Media Freedom Act, where we will have a bit more media-specific perspective as far as I've learned. And also this will be interesting how it works together with the DSA structure, so that I'm sure that for this summer weeks, I've no fear that I don't have, and we all don't have enough to think about. So I come to an end, and of course, I would like to give my thanks first of all to Eva Flecken for moderating us from Berlin. I like this, this way of collaboration in between the German media regulators, and it was a pleasure, and thanks for that. And of course, I would like also to give thanks to the representation of the state of North Rhine-Westphalia and Mr. Stein for the collaboration for this event. To all of you, the participants, Ms. Gese, Werner Steng, and Professor Cole. And then I think at the end, I would like to give thanks to all of you that have participated on this afternoon for your giving your time to us. And thanks to my team for preparing this event together with the colleagues of the representation of the state of North Rhine-Westphalia. Thanks a lot and stay safe. Bye.